שלוחין, ושותפין, chapter 2, 1. A non-Jew may never be appointed as an agent for any mission whatsoever. Similarly, a Jew may never be appointed as an agent for a non-Jew for any mission whatsoever. These concepts derive from Numbers 18:28, and so you shall you offer also for yourselves. This is interpreted to mean just as you are members of the covenant, so too your agents must be members of the covenant. This principle is applied to the entire Torah. Moreover, the converse is also true. Just as your principals are members of the covenant, so too in every aspect of Torah law, the principal must be a member of the covenant too. A man may appoint either a man or a woman as an agent. He may even appoint a married woman, a servant, or a maidservant, since they possess a developed intellectual capacity and are obligated to perform some of the mitzvahs. They may serve as agents with regard to financial matters. A person who does not have developed intellectual capacity, i.e. a deaf mute, a mentally or emotionally unsound individual, or a minor, may not be appointed as an agent. Normally, appoint agents. This applies both to a male minor and a female minor. Accordingly, if a person sends a son who is below the age majority to a storekeeper for oil, the storekeeper measures out an Isser's worth of oil for him and gives the child an Isser as change. But the child loses the oil in the Isser he gave him. The storekeeper is liable to pay for the father, since the child only to inform the storekeeper that he needed the oil. The storekeeper should have sent it with him to a person. Similar laws apply in analogous situations. If whoever is written explicitly told the storekeeper, send it to me with the child, the storekeeper is not liable. 3. When a person tells a colleague who owe me a money and send it to me with so-and-so, if their desires to send it to the creditor with that person, he discharges his obligation, is no longer responsible for the money, even if the person named was a minor. This applies regardless of whether the money was given as a loan or as an entrusted object. Similarly, when two people agree on a stipulation between themselves that whoever desires to send an object to his colleague may send it with whomever the sender desires. The sender may send it with whomever he sees fit, provided he is appropriate to transfer such an article. If the article is stolen or lost on the way, or the agent denies receiving it, the sender is not liable. The rationale is that every stipulation regarding financial matters that is accepted is binding. 4. When an agent buys or sells an article, he notifies the other party that he is acting as an agent for another person in this transaction. It is discovered that he violated the instructions given him by the principal. The sale is nullified. The article must be returned, even if Mashiach was performed. If the agent did not notify the other party that he was an agent, the transaction is binding, and the agent must then satisfy the principal. 5. The following was applied when Reuven purchased this field from Shimon and told him, I purchased it on behalf of Levi. Reuven drew up a deed of sale for Levi, and afterwards Reuven said, I purchased the field for myself. Draw up a deed for sale for me. The seller is not compelled to draw up another deed of sale for Reuven. If however Reuven made a stipulation at the outset telling the seller, I am purchasing it for myself, I am having the deed of sale drawn up on behalf of Levi only so that people will not know that I am the buyer, Reuven may compel Shimon to compose another deed of sale in his own name. 6. A broker is an agent, except that he receives a fee for his services. Therefore, if he deviates from the instructions of the owners, he must take responsibility for the loss he caused. What is implied? Reuven gave an article to Shimon, a broker, and told him, sell this article for me, but do not sell for less than 100 zuz. If Shimon sold it for 50, he must pay Reuven 50 from his own resources. If he sold it for 200, Reuven receives everything. Similar principles apply in all analogous situations. If Reuven claimed, I told you to sell it for 100, the broker says, you told me 50, and I sold it for 50. The broker must take an oath mandated by scriptural law, for he admitted a portion of the plaintiff's claim. If he already gave him the 50, he is required to take only a shvuas hesed that he carried out the mission, and the purchaser acquires the article. If the purchaser knew the article belonged to Reuven and the person selling to him was only a broker, he must return the article to the owner. He may, however, have a ban of ostracism issued against anyone who gave permission for an article to be sold for 50 zuz or agreed to the sale at 50 and then retracted after the sale was made. 7. The following will apply whenever a broker informs the purchaser that a specific article or piece of property belongs to a principal. Reuven, if after the purchaser acquires the article, Reuven says, I don't want to sell at this price, the purchaser must return the article. If Reuven did not specify a price and tell the agent, sell the article for this much. Whenever a broker loses an article or it is stolen or broken, he is liable to reimburse the owner, for he is considered a paid watchman. 8. The following was applied when a person takes articles from a craftsman's workplace and to send as presents to his future father-in-law's home and tells the craftsman, if they accept them from me, I will pay you for them. If not, I will reimburse you slightly for the favor. If the presents were destroyed by forces beyond his control while they were being delivered, the giver is liable to pay. If they were destroyed by forces beyond his control while they were being returned, he is not liable. More stringent will apply if he took the articles with the intent of selling them to others, telling him, if they will be able to be sold in such and such a place, or until such and such a time, I will pay you such and such. If they were not sold, I will return them to you. If they were destroyed by forces beyond control, whether while they were being transported or while they were being returned, the person who took the articles is liable to pay 9. Whenever an agent claims that a loss beyond his control occurred, causing him to lose this and this amount, he must take an oath required of agents to support his claim, and then he is released of responsibility. If the loss occurred in a place where it was likely that he would be able to find witnesses to corroborate a statement, so the matter was of public knowledge, and witnesses could thus be found, he must bring witnesses to substantiate his claim. If he does not bring witnesses, his claim is not accepted, and he is required to pay. An incident occurred concerning a person who told his agent, buy 400 measures of wine for me with money of mine that is in your possession. The agent bought the wine for him and turned out to be vinegar. The sages said such a large quantity of vinegar is bound to have been spoken about publicly, since it is possible to substantiate the claim that with witnesses, the agent must bring witnesses that the wine had not turned into vinegar at the time of the purchase and thus free himself from responsibility. If he does not substantiate his claim, he must pay. Similar laws apply in all instances regarding entities where it is feasible to substantiate a claim. When, by contrast, the claim concerns a hidden matter that is not easy to substantiate, the agent must take an oath concerning it. Similar laws apply to all claims to be issued by a partner and the like. Similar laws apply with regard to watchmen. If it is likely the claim can be substantiated, the watchman must substantiate it, as will be explained. Chapter 3.1. The following was applied when a person owns landed property that another person is using, or he has movable property that he's given him as an entrusted object, and he seeks to appoint an agent to carry out the legal procedures with that other person and expropriate that money or entrusted object from his possession. He must compose a deed granting him power of attorney, and he must perform a kidney certifying that he is granted power of attorney, telling him, take it to court, acquire it, and expropriate it for yourself, or the like. If the principal does not compose such a deed for the agent, he may not enter into litigation on his behalf, for the defendant will argue, you are not the party with whom I have contention. Even if the principal does compose such a deed, the agent is no more than that, and any property that he acquires belongs to the principal, and any expenses undertaken by the agent with regard to the dispute for which he has been given power of attorney must be borne by the principal. For this is also written in the deed granting power of attorney, and expenses that you undertake. In this case, I undertake to pay too. If the principal transfers ownership to the person to whom he gave power of attorney, granting him only a third or a fourth of the property his colleague is holding, the person granting power of attorney may enter into litigation concerning the entire holding, since he is entitled to enter into litigation concerning the portion that he owns, and he is just justified to enter into litigation with him on that. He may enter into litigation concerning the entire amount. 3. When one of a group of brothers who has not divided an estate between themselves, or one of a group of partners comes and lodges a claim on a portion of the property they assert to be their own, his claim involves the entire property, since the defendant must respond to him, since this person owns a portion of the property in question. He does not need power of attorney from the other partners. If the defendant prevails, another one of the partners cannot lodge a claim against this partner who engaged in the litigation, telling him, if I had been there, I would have raised other arguments and caused the defendant to be held liable. For the partner who engaged in the litigation can tell him, why didn't you come and raise those arguments? For this reason, if the other person was in another country, that partner can seek out the defendant and enter litigation against it, telling him, I did not agree with all the arguments my partner raised. Accordingly, the defendant can delay, telling the first partner, either enter litigation concerning only your share, or bring me power of attorney from the other party, for I am holding property belonging to both of you, and you both are involved parties in this case. Tomorrow, your brother or your partner will come and also lodge a claim against me. 4. A husband needs power of attorney to lodge a claim concerning his wife's property. If whoever there is produce on the property, he has the right to lodge a claim concerning the produce, for it belongs to him. He must lodge a claim about the property itself. Or if the wife does not own the property, he has no right to the produce. 5. Although a person has entrusted an object to a colleague or given him a loan, whether movable property or money, and appointed an agent in the presence of witnesses to bring that object or loan back to him, the option belongs to the borrower or the lender. If he desires to give it to the agent, he is no longer liable. It is free of responsibility if it does not reach the principal, for he gave it to his agent. If he does not desire to give it to the agent, he is not required to do so, for the agent is not the litigant. This applies unless the agent brings power of attorney from the owner of the entrusted object. Every person who comes to demand payment from a colleague using power of attorney is described in the verse Ezekiel 18:18. He did what is not good among his people. 6. When a person lodges a court claim against a colleague for either movable property or money entrusted to him, and the defendant has already denied it, plaintiff cannot write a bill giving another person power of attorney to collect this property and money from that person. This rationale is that he appears to be making a false statement, for he says, I'm granting you the power of attorney to take everything that I own that so-and-so has, and so-and-so has already denied possessing anything belonging to the principal. Similarly, if a person is required to take an oath in response to a colleague's claim, that colleague cannot grant another person power of attorney to have the oath administered. The rationale is that he is not transferring to the prospective agent an object of substance, and a person cannot transfer power of attorney on a claim that involves merely words. For words cannot be transferred unless they are associated with a financial claim. 7. When a person has entrusted money to a colleague and desires to grant an agent power of attorney to bring it, a kidney chalifin is not effective, for money is not required through kidney chalifin. What should you do? You should give the agent a portion of land any size and transfer the money to him by virtue of his acquisition of the land with the intent that he expropriated with his power of attorney. The agent may then go enter into litigation and expropriate the money. If a person lent money to another person, he cannot compose a bill transferring power of attorney concerning it. This possible even if the loan is recorded in a legal document. The rationale is that the loan was given with the intent that the borrower spend the money. Thus, the money given by the lender no longer exists, and a person cannot transfer ownership over an entity that does not exist. The only way that a person can transfer ownership of a debt is through a mamash shloshtan, which is a dictate whose rationale cannot be explained as mentioned above, or through a transferring of the debt by writing a deed, transferring ownership with the promissory note and giving it to the recipient. For this way, when transfer is the lien, that the note conveys. This is my understanding of the law from the Gemara. The however, ordained that one may also grant a power of attorney with regard to a loan, so that no one should take money belonging to a colleague and go to a distant country. They have also ordained that if a person was granted power of attorney to collect money belonging to a colleague that was held by another person, or to demand payment of a loan from him, and that person transferring the debt did not own the land, he could transfer to him 4 cubits of his heritage to Israel, that transferred the money to him by virtue of his acquisition of the land. Such statements appear to me to be extremely flimsy and insubstantial. For who is to say that this person has a portion in Israel? And even if he is fit to receive a portion of the land, it is presently not in his possession. The Gaonim have ordained this ruling The Genim who ordained this one did not say, let the law pierce the mountain. Instead they explained that the ruling was issued only to intimidate the defense that if he desires to enter into litigation and pay the money when presented with his power of attorney, he is no longer under obligation. Why is he no longer under obligation? For a person who brings in this insubstantial power of attorney is no worse than an agent appointing the person of witnesses. If, however, the defendant does not desire to enter into litigation with the person granted the power of attorney, he is not compelled to give him the money or take an oath until the principal comes himself. Similarly, the Genim ruled that if a person granted a colleague a loan, whether it is supported by a principal or by a kidney observer of the witnesses, even though the person denied his obligation to court, a deed granting power of attorney can be composed because the defendant is denying a claim involving a lien on property of whoever the loan is supported by a verbal commitment to loan, and it is denied. The Genim did not ordain that the deed granting power of attorney be composed concerning it. 8. When a person granted power of attorney to one individual, then desires to nullify his agency and grant power of attorney to somebody else, may nullify his first appointment. The person granted power of attorney, whoever may not grant power of attorney to another person, but the principal might not agree, saying, I do not want my property entrusted to another individual. Therefore, if the agent had stipulated that he had given the right to the power of attorney to someone else and have that person grant power of attorney to another, the agent may write a deed granting power of attorney to a second individual. The second individual may do so for a third. Everything follows the stipulation. Now, when the person who was granted power of attorney waives the payment owed by the defendant, sells him the article that was he was sent to collect, waives the obligation to take an oath, or negotiates a compromise with him, his actions are of no substance. For the principal told the agent, I seek to improve my position, not to impair it. Therefore, if the agent as the principal stipulated that the agency is effective, whether he improves the position or impairs it, his acts are binding, even if he waives payment for the entire obligation. 10. When Reuven is granted power of attorney and files a claim against Shimon, Shimon cannot turn him away, saying, maybe the principal sent you to appoint another person and nullify your agency. Reuven will tell him, give me the article that was entrusted, and I will leave my deed recording my power of attorney with you. If the principal does in fact grant another person power of attorney, he has caused himself a loss. Shimon is not liable, for he gave the object to a person with power of attorney. 11. The following applies when Reuven comes with power of attorney from Shimon and demands payment from Levi. And Levi tells him nothing like that ever happened, but if Shimon wants, he may take an oath and collect the article. He claims we expropriate the money from Levi and have it kept in court until Shimon comes, takes the oath, and collects the article. Similarly, with regard to any claim that Levi makes that is dependent on Shimon, Reuven should enter into litigation regarding the matter, and the property should be placed in court until Shimon comes and his questions. Reuven may have a ban of ostracism issued against anyone who wishes a false claim to withhold payment and delay it. If Levi is required to take an oath, he may not delay and say, I will not take an oath until I have a ban of ostracism issued in the presence of Shimon or against anyone who wishes a false claim against me. For the issuance of this ban of ostracism is merely a minor ordinance that the later Genim have ordained, so the litigants will be forthright in their claims, and we do not delay having the defendant take an oath because of this minor ordinance. Chapter 4. When a partner desires to establish a partnership, how does each one acquire the assets invested by his colleagues so that they are considered partners? If they desire to establish a partnership with money, each one should bring his money and place it on a common pouch. Then each of them lifts up the pouch. If, however, they composed a legal document detailing the partnership and had witnesses testify upon Khalifin, that each will bring 100 zuz for the partnership. The agreement is not binding. The partnership has not yet been established, for money is not acquired through Khalifin. Therefore, if they establish a partnership with regard to other movable property, when they entered into a kinyan, that one would bring his barrel of wine, the other his jug of honey, and then they would become partners. This partnership is established in this manner. Similarly, if they're mixed, they're put together and hired a property in a property partnership, and one left the jug and the other the barrel with which they desire to act as partners. This partnership is established. There are principles of all the means of the acquisition the purchaser employs to acquire property can be used by partners to acquire the assets that are contributed to the partnership too. When craftsmen join together in a professional partnership, even though they perform a kinyan with each other, they are not considered partners. What is implied? If two tailors or two weavers stipulate between themselves that whatever each of them earns will be divided between them equally, they are not considered partners. For a person cannot transfer ownership of a colleague to a colleague an article that does not yet exist. If, however, purchase the cloth for the garments with their common funds, sold them and sell them, or purchase the woof and warp with their common funds, weave garments and sell them, and a partnership has been established to the use of the money, they are partners. Whatever they earn as payment for the work, the commercial activity is divided equally 3. When the 3 partners enter into partnership, one investing the money, the second 200 zuz, and the third 300 zuz, and they all do business with the money, whether they profit or lose. The profit or loss is divided among them according to their number, not according to the size of their investments. Even if they purchase a bull for slaughter, in which instance, if they slaughtered, each of them take a portion of its flesh according to the size of the investment. If they sell the bull while it's alive and profit or lose, and the profit or loss is divided divided equally among the partners. When does it apply? When they bought and sold the money with the partnership. If, however, the money still exists within the treasury of the partnership and was not spent, but its value rose or dropped because of the currency fluctuation depending on the ruling authority of the local populace, the profit of the loss is divided according to the amount of money invested. When does it apply? When the partners enter into the partnership without making a specific agreement. If, however, is stipulated the person who invested 100 zuz receive 3/4 of the profit, the person who invested 200 1/4. If they lose, the person who would be given 3/4 of the profit would not suffer more than 1/4 of the loss, and the one who would gain 1/4 of the profit should suffer 3/4 of the loss. The money is divided according to their stipulation. For every stipulation made with regard to financial matters is binding. 4. Partners make a stipulation that they continue with the partnership for a specific duration of time. Each of them can prevent his colleague from dissolving the partnership. Neither one can withdraw until the set time arrives when the money of the partnership is exhausted. Neither can take his portion of the principal or of the profit until the end of that time. If they establish a partnership without making a stipulation, without establishing a set time, they may dissolve the partnership whenever any of them desires. This one should take his portion of the merchandise from the partnership, and this one should take his portion. If the merchandise is of the type that cannot be divided or making the division would cause loss, the article should be sold and the money should be divided. If there was a time when the merchandise of the partnership would ordinarily be sold, each partner can prevent his colleague from dissolving the partnership until the merchandise will be sold at the known time for such merchandise to be sold. Neither can take his portion of the principal or the profit until the time of the division, unless a stipulation was made between them. If the partnership was owed a debt by others, one partner cannot tell the other, "Let us dissolve the partnership until we collect all the debts that are owed to us." Instead, the assets of the partnership should be divided. When the debts are repaid, each one should be given his portions. The following was applied when the contract of the partnership owes a debt to another person. If they're not responsible for each other, they should divide the assets of the partnership. When the time for the debt comes, each one should pay his portion of the debt. If they're responsible for each other, each one can prevent the other from dissolving the partnership until the time when the person we know comes due and the debt is repaid. Why is each one given this right? Because one colleague can tell the other, since each of us can be required to pay the entire promissory note, let's continue with business with the money until the date when the payment comes. If the colleague tells him, "Let us divide the assets and you can receive all the money for the promissory note, do the business by yourself and pay the note when it comes due," the other colleague may still impede, saying, "Maybe I will lose." For two people, make a greater profit than one. 5. When a person gives a colleague money to go to a different country and buy merchandise, buy produce to sell as merchandise, or buy and sell merchandise while sitting in a store, the person who took the money may not return the money to his partner until he goes to the place where the stipulation was made and returns, buys the produce and sells it or sits in the store. The rationale is that this is considered to be fixed a time to sell the merchandise.